Ready, start. Even if there are two views possible on the basis of the evidence led by the prosecution before the trial court, when the trial court has taken the one possible view, the High Court ought not to have interfered with the said view taken by the trial court. Learned counsel for the appellant/accused therefore urged that the impugned order passed by the High Court be set aside and thereby the appellant/accused be acquitted. Per contra, learned counsel appearing for the respondent state has vehemently opposed the present appeal. Learned counsel for the state mainly submitted that in the case of multiple dying declarations, each dying declaration will have to be considered independently on its own merit as to its evidentiary value, and one cannot be rejected because of the contents of the other. It is submitted that in the present case, even though the dying declaration has not been recorded by the executive magistrate, it is clear from the medical certificate issued by PW3 that the statement of the deceased, recorded first in point of time, reveals that the deceased was burnt by the appellant/accused, who was the aunt-in-law of the deceased, by pouring kerosene from the tin and setting the deceased on fire. On the very same day, the deceased described the motive behind the incident, that the appellant/accused was compelling the deceased to go with one Mania Dhabawala, with whom the appellant/accused was acquainted, and refusal by the deceased thereto resulted into the incident in question. It is further submitted that from the post-mortem report (Exhibit 25) and severe burn injuries sustained by the deceased almost all over the body and the manner in which the burn injuries were caused would reveal that it was not the case of an accidental death. Learned counsel for the respondent state further referred to the Panchnama (Exhibit 12) and submitted that one empty kerosene container having smell of kerosene was found at the place of incident. Similarly, soil having smell of kerosene was also collected from the place of incident. At this stage, it is further submitted that even PW3 deposed that the whole body and clothing of the deceased was having the smell of kerosene, and she sustained 100% burn injuries. However, from the medical certificate issued by PW3, it is revealed that the said boy, aged about 4 years, sustained 10-12% burn injuries. Learned counsel for the respondent state therefore contended that from the aforesaid evidence led by the prosecution, it can be said that the dying declaration given by the deceased before the independent witness, that is PW3, is rightly relied upon by the High Court. It is further submitted that there was only one possible view on the basis of the aforesaid evidence which was required to be taken by the trial court, and therefore, when the trial court has not properly appreciated the aforesaid important aspects/evidence in the present matter, the High Court has rightly set aside the order of acquittal passed by the trial court qua the appellant/accused.